appear are Mr. Beanfield, Mr. Warrants, Mr. Watson, instructed by Kerry Olsen with Privy Council agents Marcus Sinclair for the BVI companies. To my right, Lord Goldsmith, Mr. Swan, Mr. Burgess, Mr. Robb, instructed by Babbe and Deborah and Plimpton for the present trustees, and then to my far right for the former trustees, Mr. Taub, Mr. Wessels, Mr. Brightwell, and Mr. Fletcher, instructed by Morant Zan, Privy Council agents, McFarland's. My Lords, just a brief update with to mention the joinder of the present trustees with effect from the 21st of September. Fort Trustees Limited and Vulcan Management Limited were appointed as trustees of the TDT, and with effect from the 3rd of October, R&H, Rawlinson and Hunter were removed as trustees of the TDT. The parties have agreed a consent.
Does that give that detail in the consent?
It gives the detail.
Well, we'd like to see that, of course. Yes.
We will pass it in. The position of R&H, I should mention at this hearing, is that they are no longer acted. Deborah Boys and Plimpton no longer act for them. They're now separately represented, but don't intend to instruct council. My Lords, as to the issue of the hearing timetable,
right.
As your Lordships know, there are two rival timetables, one put forward by the BVI companies and the former trustees, one by the present trustee. My Lords, there's no dispute about the basic running order. It's only about the precise timings within that running order, and we rather see that as a matter between the two sets of trustees to argue further about that allocation. Everybody agrees that we, the BVI companies, should have the whole of this session to deal with the Article 32 issues, so we don't need to argue about that for purposes of this afternoon, and I would hope that as the other once we get through that, the other allocations of time can be agreed before we get there. The broad shape of these days that has been agreed is that Article 32 will be dealt with today and tomorrow, contractual limitation broadly on Wednesday morning, and from Wednesday afternoon it will be restitution, and then Thursday afternoon would be Guernsey 3.
Well, if you haven't agreed a timetable between you by 10 o'clock tomorrow morning, we will impose one on you, I mean on everyone. The differences seem to be marginal, but we'll have to do the best we can, but we won't conduct this hearing after today without a timetable. Today it doesn't matter.
Well, I'm very much obliged.
So we need to know in the registry before 10 o'clock, so we can consider it at 10 o'clock, what the position is.
Very much obliged. Your Lordship has picked up that there are very small amounts of time that are actually in dispute, and we, for the BVI companies, have actually said that we'd be content with either timetable. My Lord, moving to Article 32, if I may. These submissions this afternoon, I'm going to cover the BVI company's appeal on the applicability of Article 32, both as a matter of private international law and as a matter of statutory interpretation. I'm going to deal with the connected question of the interpretation of Article 32, which is relevant to its applicability in the facts of this case, and which is raised directly by the present trustee in the interpretation appeal.
We were going to say that, I think, almost exactly what you've said, so namely that there's an interlink between interpretation and application, and that you need to understand what Article 32 is doing before you can work out, you can categorise it and work out which law ought to apply.
My Lord, I'm going to deal with both matters. They are connected, as your Lordship rightly points out. And the last matter will be any remaining issues of costs if time is permitting. Your Lordships will recall in the proceedings below the former trustees sought declarations on whether they had incurred liabilities to, among others, Glenalla, Thorson and Oscar Tello. They sought unsuccessfully before Lieutenant Bailiff Chadwick, but successfully in the Court of Appeal, declarations that pursuant to Article 32(1)A of the Trust Jersey law, that the former trustees had no personal liability in respect of any such liabilities, and that the claims of the BVI companies extended only to the trust property of the TDT. Now, the BVI companies say that the Court of Appeal was wrong in that matter, both as a question of the application of the principles of private international law and as a question of statutory interpretation of Article 32. Now, there are three obligations, as your lordships know, owed or potentially owed to the BVI companies, which are affected by this. There are two loans, which the existence of those loans is not a matter of dispute. There is now, your lordships may be relieved to hear, an agreed statement of facts and issues, which I think has been provided in a separate bundle, a separate document, which identifies these loans at paragraph 24. The loan owed to Glenalla was 78 million euros odd. The loan to Thorson, 80 million pounds odd. They were loans novated in August of 2007 from being liabilities of the Chengi Family Trust, the TFT, to become liabilities of the Chengi Discretionary Trust.
That's where the SFI is. The agreed one, we've seen the...
It's a document like that.
There's one that came in
It
quite
was
recently.
produced yes, very shortly. Guernsey one, yes.
It's so recent I haven't got it in the bundle, I've got it loose, but there is now an agreed, and I was referring to, within the statement of fact, I was referring to the references to these loans at paragraph 24 on page 9. Now, as to the restitutionary liability to Oscar Teller, which we say exists, Lieutenant Bailiff Chadwick found there was such a restitutionary obligation in a sum of about £39 million. The Court of Appeal, however, disagreed and said there was not, and that, as your lordships know, is the subject of a separate appeal. Now, if we are successful in that appeal, the restitutionary appeal, that we say that much the same arguments and points that we make today as apply to the contracts would equally apply to the restitutionary obligation, because that equally is not an obligation governed by Jersey law. Now, turning first, my lords, to the private international law issue, to put the matter, I hope, succinctly, the question before the board here is whether one is dealing with an issue which is governed by the law of the obligation, as the BVI companies say, and I think with conditional support from the present trustee, or is it governed by the law of the trust, as the former trustees say. Now, the TDT, as your lordships know, is governed by Jersey law. It was administered in Guernsey, and the proceedings in this case took place in Guernsey, but it's governed by Jersey law, and Article 32 is obviously part of the Jersey law statute. Now, the Lieutenant Bailiff found that the loan agreements in this case were not governed by Jersey law. The possible alternatives he found were the laws of the BVI, England or Guernsey, but he found it unnecessary to decide that question because it wasn't Jersey law. And the Court of Appeal did nothing to interfere with those findings so far as the governing law of the loan agreements is concerned. So one is dealing with loan obligations which are not governed by Jersey law, and...
not governed by Guernsey.
Sorry, not governed by... not
Jersey.
Jersey law. Not
Jersey
governed by
law.
Jersey law. And the same is true of the restitutionary obligation if it exists. Due to a late consensus, which your lordships will find in a footnote 5 on page 23 of the agreed statement of facts, the position of all parties is now that if there is a restitutionary claim, English law applies. Which will save time, I hope, when we come to deal with the restitutionary appeal. But the restitutionary claim is not a Jersey law obligation, is the point for present purposes.
What are the possible laws in the matter of restitution claim?
The realistic competing law was Guernsey law.
Yeah.
Now, the matter before the board poses the question in our submission of how one characterises the issue or issues before the board. And in our submission, it relates to the law of obligations, and in particular, whether the debts owed by the former trustees are discharged by the provisions of a statute which is not part of the law of the debt. And that is what we say is the true issue that is thrown up on this appeal. We have referred in our written submissions to my Lord Manser's well-known guidance about the process of characterization in the English Court of Appeal in the Rawlinson case in 2001.
Raiffeisen, I think.
Raiffeisen.
I think it's an Austrian company, or yes, anyway, it doesn't matter.
My Lord,
No doubt,
I've no doubt,
whichever way.
I've certainly heard both you. I'm happy to take it from your Lordship.
The correct German.
It's Raiffeisen. Your Lordships, on the electronic bundle, the passage I was referring to is at MS 24592. In the hard copy bundles, it's bundle 12, tab 145, at page 18 of the report. Sorry, no, I beg your pardon. Page 840 report, and it's a well-known.
What tab?
It's tab 145, bundle volume 12 of the authorities, tab 145, my lord.
And the MS number?
The MS number for the passage is 24592.
24592, thank you.
And it's the passage on the page between B and D, letters B and E. I won't read it out for your Lordships. It's well known. Your Lordship said there was a three-stage test involved. One, you characterize the issue. Two, you select the conflicts rule, which lays down the connecting factor for that issue. And then you identify the system of law applicable, which is applicable in accordance with that rule. Now, your Lordship, importantly, at paragraph 27, also made the points that it does not follow that at the first stage you should ignore the effect on stage 2 of characterizing an issue in a particular way. The overall aim in the end is to identify the most appropriate law for the issue. And your Lordship rightly points out that the conflicts rules are man-made, they're not natural, and they don't have any inherent value beyond their purpose of selecting what is the most appropriate law. Now, in that case, the Court of Appeal preferred the contractual analysis, noting, as your Lordship did page in the report, over the page at 842, by letter C in paragraph 34, your Lordship noted that party autonomy was the dominant theme influencing modern international view of contract. And at the same page, just by letter D, your Lordship said this: under a contract which from its outset purports to confer on a third party a right of action, an issue whether the third party may enforce that right appears to be again essentially contractual. An issue whether following an assignment the obligor must pay the assignee rather than the assignor falls readily under the same contractual umbrella. Now, in that case, the question was who could enforce the contractual right which had been assigned. But in a sense, our case is more obviously contractual because it's about whether rights purportedly given to Glenalla and Thorson under loan agreements have been discharged or perhaps radically changed. So the question is what rights Glenalla and Thorson have under the loan agreements. My Lords, we've also cited in our written submissions a decision of Mr. Justice Hamlin, as he then was, in Secure Capital, which is in volume 14 of the authorities at tab 166. And the MS number for the passage is 25309. This is a decision of Mr. Justice Hamlin. It related to a financial note issue where the issue documentation included a term saying that there were no misleading statements in the issue documentation. And the claimants in this case acquired an interest in those notes, as is common at several stages removed from the issuer. The notes, as is common in these issues, were deposited with a common depository. That was held, the notes were then held on behalf of a clearing system, Clearstream, and dealings between holders were then, took place between accounts and the clearing system. So there was no, the claimant had no contract with the issuer, but wished to sue the issuer for breach of the no misleading statements term. And Mr. Justice Hamlin in that case held that the true issue was a contractual issue. It was who could sue for the misleading statements, a breach of or infringement of the misleading statements term, and that was governed by English law, which is the law of the notes. The competing contention, I should say, by the claimants in that case was that it was an issue under Luxembourg securities law, which purportedly entitled them as an additional bearer of the notes to bring an action for breach of that term of the notes. And at paragraph 32 of that report, the MS number being 25314, paragraph 32, and in the report number, it is page 561, the learned judge cited my Lord Mance's guidance and decided that further on at paragraph 51 on page 564 of the report, that the claimant's analysis was an artificial analysis, and said at paragraph 52, for all these reasons, I have no doubt that the correct characterization of the true issue is that it is contractual. Further, however one characterizes the issue, given that it involves enforcement of rights against Credit Suisse, that's the issuer, under the notes governed by English law, it's difficult to see how the appropriate law can be other than English law. Now, the Rome I regulation does not apply in Guernsey, and accordingly, we have included in the bundles an extract from the Dicey Morrison Collins 11th edition from 1987, which is the edition which applied before the Rome Convention, in order, just to show your lordships what effectively the common law was thought to be at the time. And your lordships, in the MS number, will find that at page 1236, and in the hard copy authorities, it's in bundle 16 at tab 209.
Did you say 1236?
1236, I hope that's not a misreference, my lord. I'll check that right now. Sorry, I have got that wrong. 26201. It's a misreference. I do apologize. 26201 in the electronic. 26201. And I hope your lordships will there find in the 1987 version Rule 186 of Dicey, which has the rather unsurprising proposition at sub-rule 1, the effect of a contract, i.e. the rights and obligations under it of the parties here too, is to be determined in accordance with the proper law of the contract. Now, the Rome I regulation equivalent is Article 12, which your lordships may be interested to see. It's in bundle 1 at tab 16. And in the electronic version, it's, I hope this reference is right, 20299. Article 12, I stress, it doesn't apply to Guernsey, but yes. I look at this for comparison purposes. And Article 12, one sees scope of law applicable. One, the law applicable to a contract by virtue of this regulation shall govern in particular A, interpretation, B, performance, and we'd also draw attention to D, which is the various ways of extinguishing obligations and prescription and limitation of actions. Now, the rule for which we contend, we have for convenience labelled in our written submissions the discharge rule, which was in our submission conveniently expressed in the Re-Helbert-Wag case, which, if your lordships wish to look up Mr. Justice Upjohn's rather pithy statement in that case, it's at bundle 28, tab 387, and in the electronic bundle 30649. And one sees there just at the end of the first paragraph on the page, Mr. Justice Upjohn says this: the power of legislation to effect a contract by modifying or annulling some term thereof is a question of discharge of the contract, which in general is governed by the proper law.
30649.
30649, my lord. Top of the page, end of the first paragraph.
Oh, yes. Yes, I think, yes.
Now, that raises the question that my Lord Mance has already mentioned of what Article 32.1a does. Now, I will come back to this on the question of the detailed interpretation of how it works, But for present purposes of dealing with the private international law issue, the BVI companies and the former trustees and the Guernsey Court of Appeal agreed, or are agreed, that one thing that it does is it discharges the trustee from personal liability under the contract. That is a common ground, certainly as I understand it, between the BVI companies, the former trustees, and the Court of Appeal in this case. Now, that brings me to Article 32 itself. We had to, of course, get there sooner or later, and that is in Authorities Volume 2 at tab 22, the electronic pages 20430 for the article itself. The article is on page 22 of the statute. And I won't read the article out because I'm sure your lordships I've taken a look at it. But you will see that there are, it distinguishes in 1A and 1B between a knowing third party and a party who doesn't know that the trustee is acting as trustee. And the Grand Court, I'll go there if your lordships like, but it's probably unnecessary, at paragraph 52 of their ruling in this case, agreed that it was a question of discharging the trustee's liability. The uneffect of this article was that 32(1)A discharged the trustee's personal liability, and the Court of Appeal used the word discharge in three other places as well, paragraphs 29, 39 and 45 of their judgment under appeal in this case. Now, the present trustee's case is that the Article 32(1)A operates as a cap on the personal liability of the trustee limited to the value of the trust assets. Now, that's wrong for reasons I'll come to, but in any event, that interpretation would operate to discharge the trustee's personal liability beyond the value of the assets. So it would still, in our submission, be a discharge case. And we say the question it's a question of discharging or modifying the contractual rights, and that ought to be governed by the proper law of the contract or whatever the obligation is. Now, we have cited at paragraph, I won't go there for your lordship's notes, in paragraph 36 of our written submissions. It's in Appeal Documents, Bundle 2, tab 23, and the electronic number, I'm not going to go there unless your lordship wish to go there for all the authority citations, but
Can you give us a number?
the electronic number is 13813. 13813, it's paragraph 36. We've cited numerous authorities to show that this rule, we've termed the discharge rule, has been consistently applied by English and Commonwealth courts for quite a long time, and in many different contexts. I'm obviously not going to cite all the authorities which are footnoted.
The most famous case is one we were mentioning before, I think, probably the National Bank of Greece and Metlis, that type of...
Metlis is certainly a famous case and an in-point case. The other one I was going to mention, my lords, is the insolvency rule, because one of the best-known applications of the discharge rule is in insolvency, where a foreign insolvency will not discharge, generally will not discharge an English law debt. That's sometimes referred to as the Gibbs rule after that case, Gibbs and Société Industrielle, which is at volume 6 at 74 and in the electronic 22349. And the relevant passage from Lord Isha, Master of the Rolls, is the passage at pages 405 to 406 of the report, and 22349 in the electronic. I won't read it out, it's quite a long passage. It makes the discharge rule point. And the point really is that what Lord Isha, Master of the...
Page again?
Page in the hard copy report 405.
Thank you.
405, and the passage starts about 6 lines in, the plaintiffs contend, and it carries on to the middle of the following page. For obvious reasons, I won't read that out, but that rule, which applies in insolvency, has been applied in England ever since, and it's also been applied by the board. It was applied by the board in a case called New Zealand Loan and Mercantile Agency, for which, for your Lordship's notes, I won't go there unless your Lordships wish me to, is in the hard copy bundles at bundle 11, tab 129, and in the electronic version at 2409, where Gibbs was applied by Lord Davey. Now, there have been criticisms made of the Gibbs rule over the years, particularly as to whether an English court should take a more flexible line in relation to foreign insolvencies. But Gibbs has always been applied as a matter of precedent, and the force of those criticisms has really been blunted when the Navigator case in the Privy Council, where Lord Hoffman wished to take a more flexible approach in recognising foreign insolvencies, so decided in Navigator, but then we had Rubin in the Supreme Court that said Navigator was wrong on that point. So we're back to Gibbs as a matter of authority. And there are many other instances of where this has been applied, third-party debt orders, cases where there's a case there with English third-party debt order does not discharge a Hong Kong debt, and so forth. Now, the former trustees seek to dismiss this long-established line of authority as saying that these are all cases about subsequent legislative changes after the contract has been made. My Lords, that's not a relevant distinction. The foreign insolvency regimes, for example, will of course usually exist at the time of the contract. There's no reason to suppose that the outcome of the exchange control cases would have been any different if the exchange control legislation had preceded the contract. The rule in our submission is that a contract governed by one law is not discharged by a foreign law statute, which is not, and it's not qualified by any sub-rule that says that it can be discharged if the statute is pre-existing or already exists. Your Lordships, we cited in this regard, we cited Adams in the National Bank of Greece as one of our authorities. That was a case where Greek legislation retrospectively sought to absolve a Greek bank from English law liabilities, which was held to be ineffective. This is not a timing point. The only purported justification put forward for the former trustee's position is to say, well, if you know the legislation in advance, you can conduct due diligence as a creditor. Well, that, of course, begs the question of whether the creditor should expect the contract to be governed by a foreign law. And in our submission, given the long-standing nature of this rule, it's entirely reasonable for a creditor to assume that a pre-existing Jersey law statute will not apply to, for example, an English law contract. Now, so far as the Court of Appeal is concerned...
No reason for choosing English law.
Well, indeed. They may have a very good reason, which comes back to your Lordship's point on party autonomy, which is they may have deliberately chosen English law because they did not want their contractual obligation to be affected by an insolvency regime in a particular different state.
Well, one has to say it's slightly odd to see, although they're rivals, Jersey and Guernsey, treating each other as foreign powers.
Indeed, my Lord, although there is authority that their laws are different in a number of respects. Yes, there is authority that one can look at one when informing oneself about the law of the other, but equally the cases say that is something of a dangerous exercise, and one should not assume the laws are the same. And in many... You
have to treat them as separate legal
Yes,
systems,
and in many areas they are different.
Those are differences normally introduced by statute.
Often introduced by statute, but not exclusively, my Lord. There is a case in our bundles, Vodun and Hammond, which, if your Lordship wishes to look at it, I wasn't going to go there, but if it's at bundle 16, tab 191, where the Privy Council said, I'll just read out what Lord Wilberforce said at 582B, which in the electronic version is at 25898. And Lord Wilberforce said this: while it may be true in a very general sense that there's some basic similarity between Roman law at various periods, the various customary laws applicable to different parts of France, the civil Napoleonic Code, the law applicable in Jersey and that which governs Guernsey, this similarity is of a too general and approximate character to be of much assistance in a particular case. It covers quite clearly large differences in matters not only of detail but of principle. This is relevant, now perhaps I should just deal with this point now, my Lord, to the the suggestion that there's something perverse about the result in this case if we're right. It suggested it's an odd result that both Guernsey and Jersey should have laws excluding personal liability of trustees, but the trustees in this case can't rely on either of those. My Lord, first of all, one shouldn't assume the two laws are the same. Secondly, the argument rather falls away when you consider the position would be if the trust was governed by, for example, English law, which has no equivalent to Article 32, and it's only a black hole or some lacuna, you only view it as such, if Jersey and Guernsey were the only two trust jurisdictions in the world, which of course they're not, or they had a special relationship which meant that their laws had to be the same. So in our submission, it's not a case of just saying, isn't it an odd result that the trustees, in this case, can't rely on either statute in either jurisdiction. What happened in the Court of Appeal in this case was that instead of applying this rather long-established rule of private international law, they were lured into a novel analogy with companies and provided for a new private international rule based on status. That's in our submission. That's what they did in their ruling at paragraphs 93 to 104 of the judgment under appeal. And that in our submission is entirely misconceived. First, it's inconsistent with the discharge rule. Secondly, there is no meaningful analogy to be drawn from the conflicts rules applying to companies. There is no purported status rule which applies to companies. And thirdly, the status argument's already been rejected by the House of Lords in Adams and National Bank of Greece. So I've dealt with the discharge point, my Lord. The second point about companies, the company analogy, just to deal with that, your Lordship mentioned a moment ago the case of National Bank of Greece and Metlis. I wasn't going to go there, but for your Lordship's notes, if useful, it's in Bundle 11, tab 127, electronic page is 24000. That demonstrates there's a well-settled rule that the foreign statute that is not, sorry, I'll start that sentence again, the statute of the place of incorporation won't relieve the company of liability. That was a case where there was a Greek bank debtor, English law bonds and guarantee, Greek statute, the company was not released. Now, so far as
Adams is the second stage, isn't it? Adams is the next stage, the same case, or am I not?
No, they're two separate cases.
Adams was the case in which it was sought then to create a new company
Exactly.
which
Yes.
took over the liabilities at the point of its creation.
And it was held, well, which they argued it didn't, I think.
Yes, whether it was held.
It was held by succession, it did, yes.
I think Adams is the retrospective case where the Greek legislature sought retrospectively.
Metlis, that was the universal succession case.
Universal succession was argued. I think in Adams, I mean, one can...
Don't worry, we don't want to divert you. I think the
the
basic point you make is that almost whichever way you try, it remains actually within the discharge rule.
Yes, it certainly... Well, if one is breaking down the Court of Appeal's company analogy, one looks at the company itself and tries to find an analogy there, and the discharge rule plainly applies to companies. That's the Greek cases we've just mentioned. If you look at the position of a director, because it looks from paragraph 100 of the Court of Appeal's judgment that they may have had in mind when you're dealing with a situation of when you're dealing with a company director, because they say you're not dealing with the person as an individual who's before you. Now, liability or not of a company director depends on the law of agency. It's nothing to do with the law of the status of the company, and it's irrelevant to that. We've cited both Williams and Natural Health Foods and Standard Chartered Bank and Pakistan Shipping in our submissions in relation to that, where the position was analysed by Lord Steyn and by Lord Hoffman, respectively. And it's an issue of agency, and it would apply the same whether the director was acting as agent or not acting as agent for another individual. It's not a question of company law. There is no special purported status rule that applies to company directors, and we say there's no proper analogy. The trustee in this case does not act as an agent for any other entity. The trust indeed has no separate personality.
But is that the key? Can't you, if you had a limited partnership, would that necessarily have separate personality? I'm not sure that a German limited partnership does.
Well, I'm not sure it is key that it has, but it's certainly...
if you had a limited partnership, yes. Can't you have one without legal personality, but nonetheless where the limitation of liability of the individuals applies against third parties?
Yes,
as a matter of, I suppose, status.
Well, that's probably the position under the 1907 Act, wasn't it? Before the recent creation of a new type of limited liability partnership.
Yes. So, I mean, by statute, you can create that sort of institution, I suppose. You can do anything by statute, but they are the creation.
But there would be a
statute.
creature of statute, yes. Well, indeed.
Deal with a Kommanditgesellschaft or a limited liability partnership at your risk and knowing that it has this feature. I suppose the question here is whether that's the effect of Article 32.
Yes, and there would still be issues arising as to what the effect of having created that partnership was under private international law, as to what the liability of individual partners might be. It wouldn't necessarily be recognised in private international law principles in other jurisdictions if one created such a thing.
Well, that's the question.
It's a bit
Well,
yes, I think it.
I think it's quite a serious issue. I haven't thought about it, but the idea that we have a limited liability partnership, which has been created under the laws of this country, but is operating all over the world, and suddenly it finds itself with unlimited liability, depending on where it happens to be.
well, in my submission, my lord, that's the liability of individual. Well, there is, insofar as the corporate analogy is concerned, it's the one case that the Court of Appeal effectively cites is the Risden-Iron case. Perhaps I should take your lordships there. It's bundle 14, tab 156. And the electronic at 25080.
25080.
25080.
What tab did you say?
Bundle 14, tab 156. Now, the Risden-Iron case, which the Court of Appeal thought was of some help, and we say, of course, isn't. You had an English company operating in California, where a statute in California said that shareholders are personally liable for company debts. Now, what in our submission that is about a secondary liability of the shareholder for company debts, in addition to the company itself. And that question, under private international law, would be dealt with under the law of the relationship between the shareholder and the company. And it would not be governed by the law.
Presumably because it's intended just to affect the internal relationship. I mean, if you had a statute which says that every contract the company enters into is also to be taken to be a contract with the shareholders up to the amount of their whatever, then no doubt it would be effective against third parties, but wasn't that sort of contract?
Wasn't no.
Or statute? No.
No.
Right. So we'll hear what they say about that.
My lords, well, what they do say about that is two things, really. They say, what they say on the private international law question is two things. One, they say that the issue before the court is all about enforcement of the BVI company's claims, and enforcement is governed by the proper law of the trust. That's the first thing they say. My lords, they then make arguments, two arguments based on the Trust Guernsey law of the forum, which they say is relevant in two ways. First, they say that the Trust Guernsey law shows that the matter before the court was one that was intended to be governed by the proper law of the trust. And they say further that the Trust Guernsey law provides a mandatory rule, conflicts rule, which selects the proper law of the trust as the governing law of this issue. Now, to address the first of those, my lords, the enforcement argument, that we're dealing with enforcement, my lords, it's apparent in my submission that Article 32(1)(a) does more than one thing. Now, the article, as your lordships know, is back in volume 2, tab 22, electronic, page 201. 20431. Sorry, 20430. Beg your pardon, it's the page before. 20430. Now, it's apparent that Article 32(1)(a), which is what I'm focusing on at the moment, does more than one thing. But one thing it does is to discharge the personal liability of the debtor trustee. Now, and insofar as it purports to do that, we say that that's something that must be governed by the law of the obligation. Now, it also provides for recourse to trust property, because it says in its later words, and shall extend only to the trust property. So it provides for recourse to the trust property to pay the creditor, and we say, and the former trustees agreed and the Court of Appeal agreed, that is not affected by any breach of trust claim by the trustee, against the trustee, I beg your pardon. Now, the first flaw in the former trustees' argument that this is all about enforcement, in our submission, is that it conflates two things. It conflates the process by which a creditor establishes a liability of a debtor under an obligation, and secondly, the method by which a creditor which has established a right against a debtor may enforce it against particular assets, which of course only happens once a creditor has established a right against the debtor. Now, we've cited in our written submissions a passage from Lewin on trust, but your lordships will be aware that in some situations a creditor may be entitled to bring a direct claim to enforce against trust assets by way of subrogation to the trustee's right of indemnity. That's usually said to usually only to be appropriate where the trustee is insolvent or has absconded. So you effectively you can't sue the trustee. But in the ordinary case, the trustee is entitled itself to meet its liability from the trust assets. So before you have any enforcement against trust assets, you have a prior issue of liability of the trustee under the contract. And in our submission, the former trustee's argument, with respect, seeks to sidestep the discharge rule by ignoring the first and perhaps most important aspect of 32(1)(a), which is in discharging the trustee's personal liability. If Article 32(1)(a) applies, the creditor cannot sue or establish liability against the trustee personally, only in a representative capacity. So we say, my lords, that at a minimum, Article 32(1)(a) has no application as a matter of private international law to the question of the trustee's liability to the creditor. That's the first point, my lord. The next point is that as to other elements of Article 32(1)(a), as Lord Justice Stoughton pointed out in the Irish shipping case, which we've included in the bundles, I wasn't going to go there. It's in bundle 8 at tab 92, and for the electronic references 23134. But he made the point rightly that just because two rules of law are enacted by the same statute doesn't follow that the same connecting factor applies in each case for private international law purposes, and you cannot assume that the same connecting factor will apply. You have to examine each rule of law that is enacted by the statute. Now, it's tempting as a creditor here to adopt a slight cake-and-eat-it approach to say, well, the question of the trustees' liability must be governed by the proper law of the contract, and therefore trustees personally liable, but the right of recourse to the trust assets should then be governed by Jersey law under Article 32(1)(a), and therefore there's a right to move against trust assets unimpeded by any claim for breach of trust against the trustee. Now that's a possible outcome, and indeed it may prove to be unnecessary on this appeal, for the purposes of the appeal, to decide which law governs that second element. Because if the present trustees are unsuccessful on their retrial appeal, which is being decided on the papers, as we say they should be, then there will no longer be any possibility at that point of a breach of trust claim being made good against the trustees in this case. But if the matter is to be decided, then rather than a cherry-picking approach I mentioned, we would suggest that the correct analysis is that this article was never intended as a matter of statutory interpretation to apply to non-Jersey law debts. For all the good reasons which we set out in our written submissions, which I'll touch on a bit later, but for the additional reason that if you apply different laws to different parts of Article 32(1)(a), you start to look like attributing an allocation of risks and benefits that may not have been intended, because instinctively one feels that if a creditor is getting an improved access to the trust assets, that's a quid pro quo of some kind for the creditor disadvantage of having the trustee no longer personally liable. The two things obviously are connected, and in our submission, a coherent statutory interpretation in terms of benefits and burdens, you would expect them to go together, and that a creditor wasn't cherry-picking one and not the other. Now, of course, if the board recognises, as we say it should, that this provision only applies to Jersey law obligations, there is no difficulty because the same law applies. Now, if the board, as against that, and we say wrongly concludes that the article was intended to apply to non-Jersey law liabilities and debts, and perhaps I should say in parenthesis, if it really was intended to apply to non-Jersey law debts and to effect a fairly radical departure from the pre-existing law, you would expect to see, and in my submission would need, an express provision along the lines of what we see in the Guernsey law, in the Guernsey, the Trust Guernsey law, which is
42.4.
42.4, which is conspicuously absent.
42.4?
42.4. It's at
Where's that?
in tab 1, bundle 1, tab 21, and electronically it's at 20375. And section 42 of the, and in the statute it's pages 13 to 39, internal numbering of the statute. Now,
And which one is it? 40?
it's 42. Section 42.
Oh, it's 40. It's over the page, yes.
Yes, is a broad equivalent in Guernsey of Article 32 in Jersey, but it has a particular, very conspicuously has a provision that Jersey doesn't have, which is at the top of page 39, where sub 4 says this section applies to a transaction notwithstanding the lex causa of the transaction, unless the terms of the transaction expressly provide to the contrary. Now, in my submission, if one was going to run to effectively override that line of private international law authority that I have mentioned, you would at the very least expect that type of provision, which you do not have in the Jersey statute. Now,
Just help me what it means, or what you say that 1A actually means in practice. And I think you said a moment ago that everyone agrees that insofar as it deals with recourse against trust assets, any breach by the trustee is irrelevant. So how does it work? You have a third-party claim against the trustee as trustee, and you say, well, if that's a Guernsey claim, then this is irrelevant, that bit's irrelevant, it can't limit because of the discharge rule. Then what's the next bit mean? And it shall extend only to the trust property. Let's suppose it were a Jersey proper law claim. How would the claim be limited to the trust property? Is it a limitation which applies when the trustee comes to reimburse itself, or is it a limitation? Is it suggesting that somehow the third party could have a claim direct against the trust property? Or
Is it about enforcement, perhaps? Because generally, unless this is a claim in rem, which it's not, a claim is not against property, it's against a legal being.
Right.
So this actually only makes sense on the footing that the claim is, as it's envisaged here, against the trustee, but the right of enforcement is limited to the trust property.
yes, my lord, the way we say that this works is that it effectively creates a statutory non-recourse scheme. Now, what I mean by that is that the personal liability of the trustee to meet the claim from its personal assets is discharged, that the trustee is sued in a representative capacity, and the creditor is entitled to be paid from the trust property. Now, we say also that the creditor's entitlement to be paid from the trust property is not affected by any breach of trust claim against the trustee, and that if the trust assets are exhausted, there's no further claim against the trustee. Now, that's the interpretation which the Court of Appeal favoured in paragraph 52 of their second judgment. The interpretation, I think, which is largely subscribed to by the former trustees as well. Well, I was going to come to the interpretation of the article in terms of how it works shortly, and if I could do that, if I could just first of all just conclude with the private international law issue. If I was addressing the question of whether different parts of this article might be governed by different laws and have different connecting factors, we say, well, actually, it wasn't intended to apply to foreign law obligations, so there isn't actually a difficulty there. But if the board came to the conclusion that it was necessary to decide this point and that potentially different laws applied, we say, well, either we as a creditor are entitled to effectively have the best of both worlds, which is that there's personal liability because of the governing law of the obligation, but we can proceed against trust assets under this article, or both elements must be governed by the proper law of the obligation at the second stage, because the second stage is still concerned with what the rights and obligations of the parties to the contract are, including what rights does the contract confer on the third-party creditor. And the second part of Article 32(1)(a), by second part I mean, and shall extend only to the trust property. If it applied, it would be changing the rights of the third-party creditor and effectively, rather than entering into a recourse loan with the trustee personally liable, you are in fact entering into a non-recourse arrangement where the trustee is not personally liable, but your recourse is limited to a specific pool of assets. Obviously, if one did that by way of contract and chose for it to be governed by English law, nobody would conceptually have a difficulty with that. But if your lordships took the view that there must be one law that applies as a matter of private international law to the whole of the article, we would suggest in those circumstances that it must be the law of the obligation.
I mean, the simple reading of this is that you've got a claim against the trustee. If this article applies, you only have a claim against them qua trustee, and the explanation is that that means you can only recover from them to the extent of the trust property. Everything else is between them and the beneficiaries. They are liable to third parties to the extent of the trust property, full stop.
Full stop.
And they may be unable to recover recourse because they may have been at fault, if that is the test of their liability or whatever.
I mean, how would this work in practice? Because suppose you've got a debt assumed by a trustee known to be acting as such of 100,000, but the assets of the trust are only worth 50,000. Do you sue for 100,000 and the defence says we will prove that the assets are only worth 50,000, or do you get judgment for 100,000, but you can only enforce against the trust property for whatever it turns out to be worth? Just as a matter of mechanics, how does this happen?
Well, I would suggest that you sue the trustee in a representative capacity.
For the full amount?
You would be entitled to a judgment against the trustee in its representative capacity for the full amount, but you would only be entitled to enforce against trust assets. So once the trust assets were exhausted, if you didn't have your 100,000...
Why? Why is it? Why can you only enforce against trust assets? It only extends only to the trust property, but that could simply be a limitation of liability. The trustee must cough up. It has a personal liability, but up to the extent of the trust property, you're able, I imagine, to execute against the trust property if you're a third party. But if you execute against the trustee's other property, the trustee may be in difficulties if he's been at fault in getting an indemnity. Is that a possible alternative?
Well, we say it's not, my lords. If I could, just to address your lordship's point on how we say the...
You have to read 1A along with 1B. 1A has the words that are there contained, while 1B is the one that talks about the personal liability of the trustee. And the argument, I think, against the position advanced by my lord and the chair is that when you read the two together, you see that 1A is designed to exclude the personal liability of the trustee.
Yes, I mean, I think your lordship has very neatly made the point. I think if you step back and consider the common law position that this was enacted against, you have a position where a trustee is personally liable on contracts as a general proposition. The trustee may have a right to be indemnified from trust assets, and that indemnification may be affected by a breach of trust claim, if there is one. Now, where this article applies, the trustee in 32(1)A is liable as trustee in the second line. Shall be, if the other party knows that the trustee is acting as trustee, any claim by the other party shall be against the trustee as trustee and shall extend only to the trust property. Now, that is distinguished from B, which says if the other party does not know the trustee is acting as a trustee, any claim by the other party may be made against the trustee personally, although without prejudice to his or her liability, the trustee shall have a right of recourse to the trust property by way of indemnity. So you have distinctions there, as my lord has pointed out, between as trustee in A and being liable personally as in B, if there is an unknown, if the creditor doesn't know there's a trustee involved. And so the trustee's personal liability in A is being discharged. And we say as a matter of analysis, well then, if you have no personal liability, there's no, you have no personal loss to be indemnified, you have no need to rely on your indemnity. And in relation to A, the trustee indemnity therefore becomes irrelevant because he doesn't have personal liability. You contrast B, where the trustee does have personal liability, and he has an express right to be indemnified, because, well, his indemnity is expressly mentioned, I should say, at the end of B. Now, so under A, you have effectively a statutory right of recourse against trust assets. When it says, shall extend only to the trust property. And we say, when it comes to the issue of interpretation, that the words in A are not capable of bearing the meaning that it's just a cap on liability limited to the value of the trust assets.
I mean, an alternative possibility is that by creating a separate status for the trustee when he acts in that capacity, A is effectively requiring the court to treat the trustee in that capacity as a separate legal entity from the trustee in any other capacity. Because otherwise, it's hard to see how, without a distinct entity being at least in some way created, you can speak of a trustee as having a separate capacity as trustee.
Well, the trustee, we made the point in our written submission by law that the trustee, that Jersey law does recognise trustees being sued in a representative capacity in its procedural rules.
In the rules.
But what does that mean?
Well, it means, in my submission, it means what I mentioned a moment ago, that the trustee can be sued in a representative capacity for the full amount of the debt, but the debt is paid out of trust assets such as they are.
Well, it's either got to be a limit on enforcement, which doesn't seem consistent with the fact that it is the claim that is only to extend to the trust property, or else it's got to be that for certain purposes a trustee in his capacity as such is treated as legally distinct from a trustee in his personal capacity.
Well, I would suggest, my lord, it isn't necessary to go so far as to say he's treated as legally distinct, or as a separate entity, which of course would run contrary
Well,
to...
let's say legally distinct, because it has fewer red rags attached to it.
Right, because I'm
But,
sure quite a lot
I
of
mean-
trust lawyers would get very excited about the idea of the trust having separate identity or separate legal personality. But certainly, I don't think there's much between us, my lord, because I think what we are saying is that it is sued in a special capacity, which is to say, we say a representative capacity, and there are provision in the rules for that to be done. And you then have your remedy against the assets. And if the assets are exhausted and you're still not paid, then that's tough on the creditor.
Another way of looking at the same thing would be to say that when in Jersey law, after the enactment of this provision, a trustee contracts, he contracts qua trustee because he has two separate patrimonies. He has his personal patrimony, which he's not putting at stake, and he has his trust patrimony, which he is putting at stake with this contract. And so one's not talking about representing another person, but when he's acting qua trustee, he is engaging only his trust patrimony. That might be one way of conceptualizing it.
It might be, my lord. I don't think we dissent from that description, provided that one is talking about an engagement under Jersey law.
Well, that's it. There's the PIL.
Yes.
But if one's trying to conceptualize what the legislature was seeking to do,
yes,
then that might be one way of looking at it.
It could be. My lord, I digressed a little bit into the question of, and we'll save time, of course, into the question of what the clause actually means. But I ought to just address, before I develop that a tiny bit further, I ought to just rewind slightly just to address the other private international law points which I hadn't touched on.
Yeah.
And also just make good the statutory interpretation point, because the first, I mentioned that the former trustees raise a number of points. The first of which is based on section 42.4 of the Trust Guernsey law, which is at 20374, which is bundle 121. And a moment ago, Now, it's said by the former trustees that effectively that this subsection contains a rule of the forum, the Guernsey private international law rule, where
What was the reference again?
it's 20376.
2. Thank you.
It said that this contains a rule of Guernsey private international law which characterises the issue of enforcement of third-party claims against the trustee as a matter of trust law in the context of Guernsey Trust. So they effectively say that this subclause shows that Guernsey should characterise this issue in the same way in relation to a foreign trust, as to say in our case a Jersey law trust, as being governed by the proper law of the trust. Now, in our submission, this subsection is irrelevant to the process of characterization. What this subsection is about is, as I mentioned a moment ago, is it lays down a private international law rule for Guernsey law trusts in the Guernsey courts, which displaces the usual common law rule that an obligation can only be discharged in accordance with its proper law, a rule which is absent from the Jersey statute. This section applies only to Guernsey law trusts. It's part of Part 2 of the statute. And if you turn back to 20345 and to Section 3.2 of the statute, one sees that a trust, the proper law of which is the law of Guernsey, is referred to in the law as a Guernsey trust, unsurprisingly. And Part 2, of which Section 42 is part, on page 20345, you see the heading of Part 2, provisions applicable only to Guernsey trusts, and Section 5, this part of the law applies only to Guernsey trusts. So the rule applies only to Guernsey trusts. It's also a rule, an overriding rule, which is, in my submission, unlikely to be applied in jurisdictions where it's not part of the law of the forum or not part of the applicable law. And we've cited in our written submissions a Dicey and Morris passage to that effect, that if you have this kind of overriding rule of the forum, unlikely to be recognised elsewhere unless if it's not part of the applicable law. But the point for present purposes is that Section 42 has nothing to do with how the issue should be characterised in this case. And if anything, I would suggest that the fact that the Guernsey law contains a specific provision of this nature, applying the Section 42 regardless of the proper law of the obligation, that tends to indicate that the obligation would generally be governed by its own proper law in the usual case. Now, my lords, the next argument made by the former trustees based on the Trust Guernsey law is an argument based on Section 65, which your lordships will find on 20390 and in the same tab, obviously, tab 21, at internal page 53. And I think the argument here, the section of this statute which applies to foreign trusts is very short. It's only two sections, 64 and 65. This part of this law applies only to a foreign trust at 64. And then at 65 it says at 1, subject to subsection 2, a foreign trust is governed by and shall be interpreted in accordance with its proper law. And I think the argument here is that the matters which are to be governed by the proper law of a foreign trust should be taken to be the same matters which, in relation to a Guernsey trust, are governed by the provisions of Part 2 of this law, the previous part. Now, that is misconceived, my lords. The Lieutenant Bailiff Chadwick and the Court of Appeal both concluded rightly that these provisions do not provide a statutory conflicts rule which answers this case. The Trust Guernsey Law Part 3, which we're looking at on page 20390, which applies to foreign trusts, it has two sections only. But first of all, section 65, in our submission, begs the question of the scope of the proper law of the trust and what applies, what the proper law of the trust applies to. And Lieutenant Bailiff Chadwick rightly noted that the BVI company's claims were not about the enforcement of the trusts of the TDT, as per the heading, in fact, to section 65, which is headed Enforceability of Foreign Trusts. And he held that the question of the trustee's personal liability was certainly not a matter of the enforcement of the trusts of the TDT, and that was to conflate two different things. And in relation to this section, section 65, and the argument on this section, in our submission, what is governed by its proper law in 65.1 is the foreign trust. It's not concerned with claims in contracts or restitution against the trustee by third-party creditors, because in our submission, those are distinct obligations which do not arise under the trust. Instead, they arise under distinct arrangements which are entirely separate from the existence of the trust. And you could, if you had to, test the matter in this way, that if, for example, the TDT had been void, so that there was, in fact, no trust still in existence, would the contract obligations still exist? And the answer to that in our submission must be yes, because they are two different things. Section 65 is directed at the enforceability of the trusts of the trust, is not concerned with obligations entered into with third parties. Another example would be if a trustee had given security over assets of the trust governed by different laws, say English law. Of course, the court in our submission would apply English law to those security arrangements if that was the law expressly governing them, and that would not be overridden by this section saying that the trust law ought to apply to a matter such as that. So that in our submission is a misconceived argument.
Basically, you're saying that Lieutenant Bailiff was right on this point.
Yes, he was. This is not about
Enforceability of the trust.
Of the trust itself for the purposes of section 65.
And there's nothing which alters the conflicts rules relating to external liabilities.
No, and nothing here. And there isn't an applicable conflicts rule that you can discern from these provisions, is our position, my lord. There's a related argument that is made in relation to section 69, which is 2 pages further on at 20392, and page 55 of the hard copy, where you will see a provision, and this is in part 4, provisions of general application, and section 69 makes provision for powers of the Guernsey court to make orders in relation to trust matters, and who can apply for orders in relation to trust matters. In my submission, again, that's nothing to do with the question of what law will govern those matters. It identifies the matters that can be brought before a Guernsey court and who can bring them. It doesn't inform you as to what law will govern, and indeed, when a matter is brought before the court will have, at that point, have to determine what the lex causa of that particular matter is. My lords, I ought to deal briefly with the question of statutory interpretation that I mentioned before, in this sense, insofar as relevant to the PIL question, that we do contend that as a matter of statutory interpretation, this section, that is to say Article 32, was not intended to apply to non-Jersey law liabilities. It's true that the article does uses general language. Article 32, back on page 20431, which is page 20430, which is bundle 2, tab 22, page 22. it uses general language. It uses the phrase, any transaction or matter affecting a trust in the introductory line. There are principles of statutory interpretation that we've explained in our written submission, that general words, that where general words are used, the rules of private international law may form a guide to legislative intention, and we've cited Benyon and so forth as far as that's concerned. The most apt examples that we have cited in our written submissions, your Lordships will see, are the cases on the statutory provisions in the states of New South Wales and Victoria, which were enacted to reduce interest rates payable on certain debts. And we rely particularly on the Wanganui case in the High Court of Australia, their highest court. For your Lordship's note, that's at Bundle 16 at tab 194, where Sir Owen Dixon refused to apply a New South Wales statute to a New Zealand debt. In our submission, a similar approach in reading this section with regard to the well-established rules of private international law is appropriate in this case. And there is in our submission, very good reason to apply those rules of construction, which they are. The first I've already mentioned, which is that it supports the coherence of the section and the working of the section for its elements to be governed by the same law and to be applicable where Jersey law is applicable to the obligation as well. It obviously assists with the coherence of the section. Secondly, it gives you consistency of cross-border application, because you don't have a situation where the debt is thought to be extinguished as a matter of Jersey law, but continues to exist for purposes of other jurisdictions, England, jurisdictions which subscribe to the other jurisdictions which subscribe to the Rome regulation and so forth, which would not recognize a discharge under Article 32 1A. It supports party autonomy because you can choose to contract under whichever law you wish to contract under. It supports principles of comity, of course, we say, and legal certainty, because at least you would know as a creditor whether your rights were affected.
This postulates, does it, that if you were litigating in the Jersey courts, you would get exactly the same result?
Yes. Yes. That they would interpret this as not applying to Jersey law debts, and it
not applying to
Jersey law debts. Yes, it would not apply to foreign law debts.
Yes,
as a matter of statutory interpretation.
It would apply only to Jersey law debts.
Did I say? I must have misspoken.
It would not apply to Guernsey law, is that
yes.
right?
Yes.
Guernsey law.
Or BGI or English or
Any other
Yes.
than
Yeah, or
Jersey?
any other non-Jersey.
Yes.
Yes. Yeah.
Non-Jersey.
Yeah.
Yes.
Because they recognise that what they've done was, by the statute, very little really. They were operating within conventional PIL principles.
Yes, and well, of very long standing, and as I've indicated, that if you were to have
Well,
departed,
the striking contrast with the Guernsey law, you say, shows that.
yes.
Well, what's the dating? Is the Guernsey law post-dating the Jersey one, or vice versa?
Yes, the Jersey statute was 1984 in its original iteration, and I think the Guernsey is 2007.
My understanding is right, that it's really, on your side, it's a very limited section indeed. I mean,
Well,
it's always looks like Jersey, which is dealing with obligations all over the place, I imagine.
Well, it's a question.
Sort of picked out this sort of category of Jersey obligations and apply some sort of special protection.
Well, it has. The breadth of its application will depend on contractual choice as to selection of the governing law of the obligation.
I suppose the Jersey law trustees might say, well, it's in our interest to ensure that we only contract under Jersey law. Might rather limit their choice of counterparties, but...
They could also, even if they contract under Guernsey law, they could in fact include a provision along these lines, which I think the Court of Appeal has held they did by implication.
Well, yes, I was going to come to that in 2 days' time. But yes.
Well, in 2 years' time, 2 days' time, it just happens that that's how it works out. So
The pure.
yes.
It comes back to party autonomy, which is, Your Lordship was previously described as the dominant influence in modern international contract law.
I'm with you.
And the parties, and if Jersey trustees can persuade parties to contract under Jersey law, then they will have the benefit of the provision.
Yep.
Now, the case is made against us to say, well, there is some restriction on these general words, which is true, which is that they only apply where the trust is governed by Jersey law. And that's the connecting factor, it's said against us. But you have to ask yourself whether that's is relevant or determinative restriction when one considers the operation of the statute in the private international law context, because we have this well-established rule of long-standing in private international law, now embodied in the Rome regulation, that stipulates that discharge is governed by property. Third-party creditors dealing with the trustee of a Jersey law trust will not necessarily assume that Jersey law and what it provides is relevant to the discharge of their debt. Indeed, I would suggest that a third party contracting with a Jersey law trustee under, for example, English law would expect the Gibbs rule to apply and wouldn't expect, for example, to be a discharge in a Jersey bankruptcy. Now, or a Jersey insolvency process, I should say. And we've mentioned that before this case, there does appear to have been uncertainty in Jersey as to whether or not this this article was intended to apply to non-Jersey law liabilities. Your Lordship has the point that Guernsey has addressed that squarely in section 42.
Where do we find the uncertainty?
It's BT and Berry. We quoted it in paragraph 93 of our submissions, which is... I'm just having that reference found. It's Authorities Volume 4 at tab 42. Where's this? I'm just finding the relevance.
21257, the electronic.
Yes, it's the foot of electronic page 21263, just at line 18. And this is a decision of the Royal Court. First, we accept that the interpretation of Article 28, that's as it was then, that's what Article 32 was then, of the Trust Jersey Law 1984 is an important and complex point of law. It should be done on the basis of known facts, not hypothetical facts. We refer again to it in a previous case. But the point being made there is that that was unresolved, regarded as an unresolved point at that stage in Jersey as to whether it applied to non-Jersey law liabilities. My Lords, that brings me to pick up where I left off on questions of interpretation in the sense of how the clause works and how it operates. So far as your Lordships have Article 32(1)(a) well in mind, it's back on 20430, the electronic bundle. I've explained how, in broad terms, we say the article operates. In terms of principles of statutory interpretation that may be relevant to that, there are only three matters I want to mention, my Lord. Your Lordships are well aware of the plain meaning rule, where if grammatically a statute is capable of only one meaning, then it ought to be applied. Secondly, to note that we are engaged in a process of interpretation rather than interpolation, and we cited Lord Staines' well-known article on this point in our written submissions, where he also refers to the primacy of the text and extrinsic materials being secondary. And in our submission, the present trustees interpretation of 1A as being a cap limited to the value of trust assets involves interpolating words into the text rather than applying the text as it is. And the third principle of statutory interpretation I would draw attention to, or consideration relating thereto, is, of course, that where a statute distinguishes between two situations, that's probably been done for a reason, and you have to investigate carefully whether that was intentional and whether the effect is intended to be different in those two situations. And in respect of A and B under 32.1, we say that that is the case here. I won't go through again how we say the article works. You've seen the juxtaposition of as trustee in A and personally in B, and also the juxtaposition of shall extend only to the trust property in A, whereas B refers to the trustee's right of indemnity. So we say it's reasonably clear that they are supposed to operate differently, and I've indicated how A works in these circumstances. It's said by the present trustee that using the words as trustee has a quote, insufficient heft to discharge the personal liability of the trustee because it doesn't discharge it in the contractual context, which generally is true. But that doesn't explain why the legislature has made that distinction here between Articles 1A and 1B and drawn a very specific distinction between liability as trustee and personal liability in B. What the article then does is sub 2 is it preserves, in Article 32.2, it preserves the breach of trust claims so that you can still sue the trustee for breach of trust, but that does not impede the creditor right in A to be paid from the trust assets, because A, as I've explained on the interpretation of how it works, the trustee's right of indemnity becomes irrelevant. Now, as to the nature of any interest which the creditor may have acquired under 32.1a, now, we've debated this somewhat in our written submissions, and we have suggested that it may create an equitable charge in the manner of a floating charge over the assets in favour of the creditors, and we cited the Swiss Banking Corporation case.
But how would that work in Jersey law, where they don't have a general law of equity? How can you get an equitable charge like a floating charge at all? I mean, because Jersey property law, if nothing else, isn't English property law.
Well, indeed, and I accept that, my lord, and I also accept that whatever view we take on how certain aspects of 32.1a are treated for private international law purposes, when it comes to the question of creating rights of security, the law of the citus is likely to become relevant as well, of the asset over which security is being granted.
Yes.
So you do have a situation there where there may be some relevance to that too.
I can't remember. It's been a while since I've sat in the courts of Jersey or Guernsey, but I can't remember whether they have a floating charge, a statutory floating charge regime or not. But if they don't have principles of equitable charges, how can there be a floating charge?
Well, it may be that they have to be persuaded to follow the Swiss Banking Corporation case and to adopt those principles that you could have an equitable charge when a pool of property is earmarked, as it were, for a particular creditor. Now, my lords, it may well be unnecessary on this appeal to decide whether there's a proprietary interest or an equitable charge or a floating charge is actually created in favour of the creditor. It would be necessary in my submission for the creditor to have some protection in relation to this, because of course the trust fund is under the control of the trustee and it could be diminished or dissipated and so on. And we did cite the Z Trust's case in our submissions, which if your lordships wish to look at it, is in bundle 13 at 155, which is a decision of the Royal Court. In 2015, and the passage that I was going to take, it's a decision of...
Give the page again.
I beg your pardon. The passage is at 25073, which is paragraph 30 of the judgment.
Sorry, can you give me the bundle?
The bundle is 13 at tab 155. And it's a decision of Mr. Clyde Smith, Commissioner. And at 30, at the top of page 25073, he says, this, as stated at paragraphs 24 and 28 of Glenalla, in relation to estates, insolvency brings about a shift towards the interest of creditors analogous to that seen in company law, and a trust that becomes insolvent should thereafter be administered on the basis that it is insolvent, treating the creditors rather than the beneficiaries as the person with the economic interest in the trust. As a matter of logic and principle, it's difficult to see how else an insolvent trust should be administered by the trustee and supervised by the court. We know this approach accords with certain advice given. Now, so there was a recognition in that case that an insolvent trust should be administered on the basis that the creditor interests are paramount. So one can see the makings of a development in the law such that creditors do have an element of protection, particularly where you have a trust which is insolvent or of doubtful solvency. But of course, at the moment, there would appear, absent an equitable charge or a floating charge, they wouldn't appear to have particular protection in other situations.
No, but if an alienation by the trustees or a payment out to the beneficiaries would render the trust insolvent, then that would be a breach of fiduciary duty on the part of the trustees if this principle applies.
It could be.
It could be, yes. Because I mean, in company law, I think it was the common law that initially developed this concept of an extended fiduciary duty, which then became part of statutory company law in 2006 in the UK.
And there have been a series of English cases that have certainly recognised that principle in corporate insolvency.
Which led ultimately to the statutory recognition, I think, if I remember right. But anyway, yes.
Well, certainly, West Mercia is the one that comes
Well, that's the
to mind.
famous one, Westminster.
The famous one, yes. Which is pretty much in those terms,
yes.
In relation to corporate insolvencies where directors are, may be alienating assets. But as I've indicated, it may well be unnecessary to decide the question of what the nature of the creditor's interest is.
Can I just follow that through by a simple example? Suppose a trust has £5 in it, and the trustee borrows well, the Jersey Trust, the trustee borrows £100, buys an asset worth £100, and then distributes it immediately to the beneficiary. He would say, well, I'm not personally liable because I borrowed this money as trustee. There's nothing in the trust fund because I distributed it. So you would say, but because he rendered the trust fund insolvent by the distribution, he ends up with a personal liability after all for breach of a fiduciary duty owed to the borrower?
Well, I think we would say that there was a liability. The question of what protection the creditor might have has obviously not been fully resolved in these cases. There is some debate in the external materials which have been relied on in relation to the statutory, the interpretation point, as to whether there was some consideration given, for example, in Jersey, as to whether they would actually enact some form of protection to make a trustee responsible for a diminution in the value of the assets or in the asset pool. And it was decided, it seems to have been decided not to enact along those lines. So you would be in a situation where the creditor was trying, potentially in quite a novel environment, to impose liability on the part of the trustee, because the fiduciary duties would ordinarily be owed to the beneficiaries and so forth, and not to third-party creditors. But I took you to the Z Trust Jersey case to show that it was at least the makings of as it were, a move towards giving the creditor some protection in those circumstances.
I mean, the argument would be that on the West Mercia analogy, that the fiduciary duty was owed to the creditor, and the creditor could sue under 32(2) for breach of trust, presumably. Is that how it would work?
Well, the creditor may have some difficulty in making a direct claim for breach of trust as being a third party who's not a party to the trust relationship.
What would his claim be then?
This is the novelty. The difficulty is, if it was a corporate situation, the creditor would ensure the company was wound up and would get the liquidator to sue any director who had alienated the assets improperly previously, and you wouldn't have a difficulty. The difficulty you have is that insolvency with trusts is not a well-trodden area so far as this is concerned, or indeed so far as priorities are concerned. And it may be that you would, in the end, be inviting the court to appoint some kind of receiver, but whether that in the end results in an effective remedy for the creditor is a question mark.
Well, it's one thing to say that you administer an estate in it as in insolvency, which is, at least in England, quite
yes,
where you collect in the assets and deal with the creditors first, and pari passu unless somebody's got a security. It strikes me as quite an exciting other thing to go on and say, and what's more, any trustee who brought about the insolvency can be made personally liable by the creditor.
Well, it's certainly an extension of the existing law. Yes. I entirely accept that. Now, whether one can build that on top of Article 32(1)(a), say I had a right as a creditor to go against these assets unimpeded by other breaches of trust, and you deliberately dissipated assets in the face of that.
Nobody else is going to have an interest if the money's been given to the beneficiaries.
Well, quite.
One would have thought that the law would look to some mechanism by which you could hold the trustees who dissipated assets responsible.
Well, you would. There is discussion in the paper, the Trustee Law Committee paper under Professor David Hayton looked, as a matter of English law, at questions of how you improve creditor rights. Amongst other things, a suggestion was that there'd be a statutory ability to create floating charges and so forth in favour of creditors. But I think I'm right in saying that he didn't provide a solution to what claim the creditor would have in these circumstances. In fact, the gist of that paper was that the law really needs to be reformed to give trust creditors better rights because they're in a vulnerable position.
Context of personal representatives.
Thank you.
I'm not quite sure where this fits into the overall argument at the moment.
Well, my Lord, it was a slight digression on the effect of Article 32(1)(a),
yes, and
whether it might have created, what kind of interest does it give the creditor. I'm reminded that there might be an argument that the claim against the trustee for a breach, for dissipating the assets, might itself be a trust asset in those circumstances. So there may be some prospect of a remedy there. My Lords, on the question of interpretation, as you will have seen, there's a lot of legislative history and extraneous materials have been cited, particularly by the present trustee. My Lord, in our submission, they are not very illuminating, save perhaps in one respect, which is that there was a quite important deletion to the articles between to Article 32, it used to be Article 28, between the 1984 and 1989 versions, and I can just briefly show you that. In the 1984 version, as originally enacted, is at page 20473, Volume 2 of the Authorities, tab 23. And one sees at the foot of that page, I hope, the old Article 28, dealings by trustees with third parties. Now, it already has distinction between knowing and unknowing third parties, but in relation to an unknowing third party, over the page on 20474, at Article 28, 2, little b, it says he shall have a right of recourse to the trust property by way of indemnity against such personal liability unless he acted in breach of trust. Now, so that's the unknowing third party scenario. It said indemnity unless you acted in breach of trust. The 1989 version deleted those words, and you see that in Bundle 1, tab 19, at electronic page 20324. And it's this is the form of Article 28 as enacted in 1989. And at page, electronic page 20324, you will see that those words were removed from little b at the foot of the page, which is the unknowing creditor situation. And B says, have a right of recourse to the trust property by way of indemnity against such personal liability. And the words, unless he acted in breach of trust, have been removed there. And there is an explanatory note from the States of Jersey legislature, which is relevant to that, which is in Bundle 33 at tab 478, electronic page 32275. Which is the explanatory note at the time of the 1989 amendment. And at page 32275, internal page 4, one sees in the first complete chunk of text, the top half of the page of the last 5 lines, first, such other parties must not be otherwise aware of their status for the conditions to apply. And secondly, the right of recourse to trust property will not in itself depend on whether the trustee is in breach of trust. Remedies in breach of trust are dealt with fully in Article 26. So it says will not in itself depend on whether there was a trustee was in breach of trust. Insofar as this sort of archaeology is at all helpful, that tends to support the situation that the access to the trust assets, the right of recourse to trust assets under the article is not supposed to be limited by any breach of trust claim against the trustee, but that is to be something to be dealt with separately. I should also perhaps briefly just deal with the reliance that's placed on the Hansard for the States of Jersey. I'll take this very quickly since time is getting on. It's reliance is placed by the present trustee on an extract from Hansard, which I think is found at 32374. And it's in tab 480, which I think may have been added to volume 33, tab 480. And there's a very long piece of text, I'm afraid, at 32374, where in the middle of the page, this is the government official who's presenting the legislation in 2006, which is the at the time of the current version of Article 32 when that was enacted. And there's a passage right in the middle of the page which says Article 11 of this new legislation replaces the original Article 32 and relates to trustee liability to third parties. This change is purely to address relatively minor drafting uncertainty advised in the previous law. It provides that a trustee's liability to third parties shall be limited to the value of the trust assets if the third party knew the trustee was acting in that capacity. Now, those words are relied on by Lord Goldsmith to support his interpretation that this is a cap limited to the value of the trust property. In my submission, that's this reliance on this extract from Hansard is not helpful. It's obviously shorthand and far from a clear statement which intends to distinguish between a claim limited to the trust assets, whatever their value, and a personal claim limited to the value of the trust assets. It's just not making that subtle distinction in my submission. And in any event, your lordships will have seen from my written submissions that the pepper and heart and the admissibility of statements by the executive about the meaning of legislation that they are promoting has gone through something of a review. And on the basis of the authorities that we cite there, I suggest that pepper and heart should be restricted in its application to situations where governments try to go back on earlier statements in Parliament, which they made during the enactment of the statute, which is not this case. But in any event, it isn't.
All right, you're dealing with an argument that hasn't yet been put, but how does it differ from your case?
Well, I think the emphasis is on value of the trust assets. And
yes,
a suggestion is made that that means a cap.
Yes, I see.
By reference to the value of the assets, rather than that your remedy is to the pool of assets.
Yes, and your point is the words value of aren't in this section itself.
They're not in the section, and also it does not appear that this statement in Parliament was intending to draw these types of subtle distinctions. Yep. And in any event, under Pepper and Hart is properly understood, it shouldn't be admissible. Finally, my lords, I should.
This is the promotion of a replacement for Article 32.
This was this is the 2006 version.
Yes.
As we see it. This is 2006 version is the one that is current now.
Right.
Finally, I should say a word about Article 26(2) and unreasonably incurred. Your lordships will find that at page 20428. Volume 1, tab 22.
I'm sorry, could you give that number again?
20428.
Thank you.
Sorry.
I think it may be in volume 2.
Sorry, I misled myself. Yes, it is 20428. Sorry, I believe I had a misreference. I think I gave the wrong hard copy reference. It's volume 2 at tab 22.
I see, yes.
Volume 2 at tab 22.
No.
The Article 26(2) is heavily relied on by the present trustee, which is headed Remuneration and Expenses of Trustee, and then at 2, trustee may reimburse himself or herself out of the trust for or pay out of the trust all expenses and liabilities reasonably incurred in connection with the trust. Now, our position, my lords, is that Article 26(2) does not affect the creditor's right of recourse under Article 32(1)(a). In our submission, Article 32(1)(a) applies to Jersey law liabilities where the third party knows the trustee is acting as trustee, and so it's dependent on the state of the knowledge, the third party's knowledge, to determine whether A and B apply. And where A applies, as we've seen, the trustee is not personally liable and the trustee's right of indemnity is irrelevant to the question of whether you can move against the trust assets. So you can have the creditor paid out of trust assets. The indemnity becomes irrelevant. That doesn't, in our submission, render 26(2) otiose, as has been suggested, because 26(2) would, of course, still apply whenever Article 32 does not apply. That is to say, if you have non-Jersey law liabilities. And it may also arguably apply where the trustee has already discharged a liability and seeks reimbursement from the trust fund. So it doesn't make a nonsense of 26(2). The other point to make on 26(2) is the once reasonably incurred, always reasonably incurred point, because at trial, the present trustee argued that even if a liability had been reasonably incurred, if you unreasonably failed to divest yourself of that liability later on, that nevertheless meant that that liability was unreasonably incurred for the purposes of Article 26(2). Now, the Lieutenant Bailiff Chadwick rightly held that that was a wrong interpretation because you had to read in the words "and reasonably permitted to subsist" into Article 26(2), which are not there. It was obviously an attempt by the present trustee to get around the need to prove gross negligence, which is required under the trust deed, and to impede the right to have to payment out of trust assets just with a test of unreasonableness rather than proving a gross breach of trust, which they were unable to do. Now, an argument is maintained before your lordships, or perhaps two arguments. I think one is to say that the present trustees, if they succeed in their retrial appeal, and they have a retrial appeal, and gross negligence is found, that they will be able to rely on this provision, and/or they say that on this appeal you should recharacterize the trustees' conduct, the former trustees' conduct, as meaning that the loan liabilities and, if applicable, restitutionary liability was unreasonably incurred for purposes of this article. Now, that is wrong on many levels, my lord. It's wrong. Well, first of all, it's wrong because the retrial appeal should fail in any event. But it's also an incorrect interpretation of Article 26(2), as the Lieutenant Bailiff rightly held, and it conflates two things. It conflates the question of whether a liability has been reasonably incurred with the question of whether the trustee subsequently acts in breach of trust. And if a trustee loses his right of indemnity in those circumstances, it's not because the liability has retrospectively become unreasonably incurred. It's because there's a breach of trust claim to be set off against the trustee's right of indemnity against the trust assets.
Why should there be that distinction? It seems if you incur an expense or a liability unreasonably, then that's the test. You can't recover. But if 5 minutes later you fail, as you could suppose under some option, to cancel it, then it's not regarded as reasonably incurred for a rather technical reason that it wasn't there at the beginning, although it will somehow gross negligence has to be proved. That strikes me as a slightly unsatisfying distinction. We're talking about indemnity in respect of expenses and liabilities. Yeah. Why should you be better off claiming indemnity in one situation than the other? I can understand why claims against the trustees should, in respect of losses, should be subject to a higher threshold. Then you're trying to foist onto the trustee some loss which you yourself have incurred. But if the trustee is seeking to recover indemnity, I would have thought one would expect a coherent, consistent test, and not sure the words reasonably incurred by themselves are quite as clear as you suggest.
Well, we entirely support the Lieutenant Bailiff's interpretation of this clause,
but because really sort of he just assumed that incurred means originally incurred. All right, that is a view, but it does lead to a rather some people might think a rather odd distinction between the type of expenses which you may recover and those which you may not. The basic test, one would have thought, when you come to recover expenses and liabilities, ought to be the same, whether you're at fault originally or at fault in failing to remember to issue a cancellation notice.
Well, one then denudes the very important clause in many trust instruments requiring gross negligence to be proved against.
No, you don't delete it at all. That's absolutely critical if you're claiming against the trustees to recover your own loss, which has nothing to do with any expenses or liabilities that the trustees have incurred, but you're just saying to them, look, you missed an astonishing investment opportunity here, there, or everywhere, or alternatively, you ploughed us into the most duff investment, and you're liable for that. One can understand that if you're seeking to put your loss onto trustees, that's going to be a higher hurdle. But equally, if the trustee is trying to put his loss onto you, one might have thought there would be a consistent hurdle.
Well, in our submission, you do have to interpolate words into the section that it doesn't say.
Well, it depends how reasonably incurred, if you look back at them. This is something which, by definition, is going to be viewed at the time when the trustee comes along and tries to reimburse himself. Have you reasonably incurred these? The answer is no. You ought to have got rid of them long ago.
Well, the section addresses itself to incurring of liabilities. It
Where
doesn't
do that. Just the words reasonably incurred again.
Yes.
I mean, that's going round in circles. It depends how much weight you put on those and whether you really think that it's a sensible distinction between recovery of the same expenses and liabilities according to precisely the nature of the negligence involved in their incurring or continuing to be incurred. There's no authority on this. I mean, you say it's an important clause, but is there nobody has ever considered?
There's no authority been cited on that point, Minor. And the reasoning of the Lieutenant Bailiff it's spelt out. It's paragraph 220 of his judgment. It's at core 1224.
The electronic is same.
The electronic is the same in this instance, my lord, yes.
Well, I mean, his reasoning is no more than you've been submitting, really,
I beg your pardon, I've given a no go.
isn't it? It says it's MS 244.
Yes, it's paragraph 220, 244. 244.
Yeah.
Of the report, where he is effective, and it's the middle part of the page where he says effectively you would have to read in and reasonably permitted to subsist into 26.2, which words are not there.
He doesn't deal with the point I've been putting to you. Anyway, maybe it doesn't concern others, but at the moment it concerns me slightly.
No, I understand that, my lord. Your lordship obviously has the point that we don't accept for a moment that any of the acts in this case would meet that test.
Right.
But
well, you're in slight difficulty under there are at least two findings of failure to exercise proper professional care on.
well, that is disputed in the submissions which have been filed, I noticed, by the former trustees in the retrial.
Yes.
And it's certainly not accepted by them, nor is it accepted by us, but it's principally an allegation against them, but it's not accepted by us that those amount to findings of negligence.
Yeah. Right, so you're near the end, are you?
I am near the end, my lord. My lords, my submission this afternoon was supposed to cover issues of costs as well. There are 3 costs appeals. I won't take up much time on this. I'll just take a couple of minutes if your lordships would indulge me.
Do you literally mean a couple of minutes?
Yes, well, I do. Well, let me be even briefer than that, possibly. We've handed in, there have been some concessions, so we have handed in a document which indicates what is still live in the 3 cost appeals, because it's not immediately obvious, and they are a little bit involved, and you'd otherwise have to go into the archaeology of the appeals.
Where do we find this
I
document?
think it was only supplied today. It was supplied.
I don't think we've got it.
We've got copies of it. It was an aid memoir. It was BVI Company's aid memoir on the status of the parties' costs appeal, which I hope will be a useful
I've got it here. I'm afraid.
Where's it?
It's,
I've got a copy, I haven't got it.
yeah,
If you would hand one in, that would be very helpful.
I wonder if my junior might hand some copies over.
I don't.
No, I don't.
So I'm not going to read out, given the time, what is in that document, but effectively it explains that certain concessions have been made and what remains live. Essentially, the former trustees at cost appeal seems to have been conceded, but our cost appeal has not been conceded, and it still gives rise to the issues at paragraph 9 of the document, which have still got to be decided, and we have filed written submissions at some length in relation to those, in relation to the non-application of Article 32, as we say, to costs orders. So those are the issues on our appeal which remain to be decided, and our submissions in writing on that are in appeal documents 2 behind tab 23, and they are at paragraphs 260 through to 281. And
Just going back to the section 26 or Article 26.2, it covers not only expenses but liabilities reasonably incurred. So, in the present context, what liabilities would we be talking about? Would that be liabilities to the trust? Because if it would, then that may put a different. Just help me.
well, I think what is being said by the present trustees is that the trustees in this case would have to rely on this clause to have recourse to trust assets to meet the loans to Glenalla and Thorson. I think that's what's being said in this case.
Right.
Manor, so that's what remains on our cost appeal. It's those items identified at 9. And the only other thing perhaps I should just mention before I sit down is that you may or may not have seen, if your lordships have had time to look at them, on the submissions on the costs appealed, R&H, the previous trustees, previously represented by Lord Goldsmith, they made some submissions about some bedders orders, suggesting that those may be relevant to the costs appeals. And in our submission, and we've touched on this in our written submissions, they are not, and indeed those are not questions raised in any notice of appeal to the board. And of course, as a matter of logic, a bedders orders would at most go to questions of priority. They shouldn't go to questions of who, as between us and R&H, should have paid the costs of what was obviously hostile litigation. If they're relevant at all, they're relevant at another stage on a question of priorities. And the priorities in relation to assets of the trusts has been directed by the Court of Appeal to be a matter to be addressed at first instance in this case. This is what they said at paragraph 15 of their order of the 22nd of December 2015. And absolutely finally, the former trustees have included some written submissions to say, well, actually, even if Article 32 does not apply, we'd quite like you to revisit the question of whether costs orders should have been made against us as a discretionary matter in the first place, because actually we weren't acting in a partisan capacity, we were acting in the administration of the trust purely. My Lord, that is not a point that was raised in their notice of appeal, and we would suggest is not therefore properly before the board, but in any event, to suggest that the former trustees took a neutral stance in this litigation is in our submission fundamentally misconceived. It was hostile and hard-fought litigation. They challenged the existence of the loans for 18 months. They are still challenging the existence of the restitutionary claim. And they are taking an active role in trying to demonstrate they're not personally liable. So it is very much a question of hostile litigation where costs should have followed the event. And in any event, that appeal, we say, is not properly before the board. And if I could just indicate, because it may not be evident, we had to serve some reply submissions in relation to a couple of matters that hadn't been raised in the notices of objection and so on. And those reply submissions, just so they don't get lost, are at tab 42 of volume 3 of the appeal documents. And those were on the questions of restitution and yes, and the arguments based on Article 69 in relation to the application of Article 32. Some material there that touches on that as well. My Lords, I'm grateful I've overrun my time. I do apologise.
We started a little late, so not so bad. But, thank you very much indeed. We shall look forward to an agreement of the statements of facts and issues tomorrow, and look forward to hearing further submissions then. Ten.